If you were born before 1966, you are actively being overcharged by up to thousands of dollars every single year, simply because corporations are legally hiding 7 specific financial exemptions from you. These are not government handouts or temporary relief programs. They are binding legal protections written into law specifically for your age group, designed to shield you from aggressive taxation, utility hikes, and banking fees. But there is a massive intentional catch. The law does not require these companies or local governments to apply these exemptions automatically, meaning if you do not know the exact name of the bill to quote over the phone, they will gladly stay completely silent and keep draining your bank account. Today we are putting an end to this predatory silence. Over the last decade, I have dedicated my life to consumer protection and financial advocacy, poring over thousands of pages of obscure legislative texts, state mandates, and corporate loopholes that are intentionally designed to be unreadable to the average person. I have watched countless hardworking Americans, people who have paid into the system their entire lives, get squeezed by corporations taking advantage of their lack of inside knowledge. In this video, I'm going to walk you through exactly what these 7 exemptions are, how they are secretly affecting your daily life right now, and the exact words you need to say to claim your money back. We are going to cover everything from your property taxes to your utility bills, and I am saving the most guarded, high-stakes exemption for last, one that could literally save your family's estate from being seized. Grab a pen and paper because you are going to want to write these down. Let us start with one of the most significant financial drains you are facing right now, your property taxes. If you own your home, you have likely noticed your property tax bill creeping up, or in some cases, absolutely skyrocketing over the last few years. Local governments use automated algorithms to reassess neighborhood home values, constantly inflating the supposed value of your property so they can tax you more on it. This creates a terrifying situation where you could be entirely debt-free, with your mortgage fully paid off, but still find yourself at risk of being priced out of your own home simply because you can no longer afford the taxes. But if you were born before 1966, you are likely exempt from these relentless reassessments under various state-level senior homeowner protection acts. What the tax assessor will never voluntarily tell you is that the law in many jurisdictions allows you to completely freeze your property, EAS or TM's assessed value, the moment you hit the qualifying age. This means that even if the houses around you are selling for triple what you paid, and even if your local government decides to hike the tax rate, your specific property is legally shielded. Your assessment remains locked in time. However, this is treated as an opt-in exemption. The county will simply continue to send you the higher bills, and if your taxes are paid through an escrow account, your mortgage servicer will blindly pay the inflated amount using your money without ever raising a red flag. To stop this, you must proactively contact your county tax assessor, TM's office, and demand the senior assessment freeze application. Do not ask them if you qualify. Tell them you are calling to exercise your age-based assessment freeze. Once that paperwork is filed, it can instantly stop the bleeding and in some cases legally force the county to refund you for the years they overcharge you after you became eligible. Now think about your banking and the monthly bills you receive. We are living in a digital age where every corporation is aggressively pushing you to go paperless. They want you on auto pay, they want you receiving emails instead of letters, and they penalize you heavily if you refuse. You have probably noticed new charges on your credit card statements, bank accounts, or cell phone bills labeled as paper statement fees, administrative processing fees, or convenience charges. If you rely on the postal service to pay your bills by check, you have also likely been hit with massive late fees because the mail was delayed by a day or two. Ask yourself this: did you know that major banks and telecom companies collected billions of dollars in late fees and paper statement fees last year alone, and the vast majority of that money was extracted from older adults? This brings us to the second protection, the digital financial accessibility mandates. Federal banking regulators and many state consumer protection bureaus recognized that the forced transition to digital banking was disproportionately penalizing older Americans. Therefore, legal provisions were put in place stating that individuals over a certain age threshold cannot be legally charged fees for requesting paper statements, nor can they be subjected to automated late fees when a postmark proves a payment was mailed on time. But again, the banks programmed their automated systems to charge everyone universally. The computer does not care what year you were born until you force the issue. If you are seeing $2, $3, or $5 charges every month just to receive your bank statement, or if you are being hit with $35 late fees because the post office was slow, you must call your financial institution. Inform the representative that under consumer accessibility protections for seniors, your account must be flagged as exempt from paper billing fees and algorithmic late penalties. They have a specific toggle in their system for this exact demographic, but they are trained never to click it unless the customer explicitly demands it. Moving on to healthcare, which is arguably the most complex and predatory industry when it comes to hidden charges. You already know that medical care is expensive. But what you likely do not know is how many of the extra fees tacked onto your hospital bills and specialist visits are entirely optional for someone your age. When you visit a clinic or a hospital, especially those bought up by massive private equity firms, you will often receive an explanation of benefits followed by a staggering bill filled with cryptic line items. You might see facility fees, age-banded administrative surcharges, or complex coding that essentially charges you extra simply because older patients typically require more administrative coordination or longer consultation times. What the billing department is hiding from you is the existence of age-adjusted medical billing caps. Under various Patient Bill of Rights legislation and Medicare coordination rules, providers are strictly limited in how much they can legally balance bill a patient born before 1966 for administrative overhead. These laws were enacted to prevent doctors from quietly passing the cost of their bureaucratic red tape onto retirees living on fixed incomes, but hospital billing software is designed to maximize revenue, automatically generating the highest possible charges allowed by their internal algorithms, completely ignoring your legal exemptions. They bank on the fact that you will be too tired, too confused, or too intimidated by the medical jargon to fight back, so you just write the check. To stop this, you must never pay a medical bill the day it arrives. Call the hospital's billing department and state clearly that you are auditing the bill for non-compliant administrative surcharges restricted for senior patients. Demand an itemized bill and tell them you want all facility fees and administrative overhead charges reviewed against your age-based billing protections. In a shocking number of cases, the billing department will magically find a way to waive those fees right there on the phone, rather than risk a compliance audit from regulatory agencies. Let us shift our focus to something you use every single day, your utilities. Energy companies across the country are quietly rolling out smart meters and shifting entire communities onto what they call time-of-use billing. This means that electricity costs significantly more during peak hours, usually in the late afternoon and early evening. This pricing model is devastating for retirees. If you are at home during the day, running your air conditioning in the heat of the summer, or turning up the heat during a freezing winter, you are being charged the absolute highest premium rates simply for trying to stay comfortable and safe in your own home. Furthermore, utility companies have become incredibly aggressive with shut-off notices, threatening to cut off essential services if you fall even slightly behind on these newly inflated bills. Here's the fourth protection you must know about: the Essential Utilities Lifeline Exemption. Public utility commissions in almost every state have legally binding mandates that protect older adults from predatory surge pricing and strictly forbid the shut-off of power or water for vulnerable age groups, particularly during extreme weather months. If you were born before 1966, you are legally entitled to be placed on a flat-rate protected tier that completely bypasses the time-of-use surge pricing. You are also entitled to medical baseline exemptions if you use any medical equipment at home that requires electricity, which further drops your rate, but your power company will never automatically switch you to this cheaper, protected tier. They will send you glossy brochures praising their new smart meters while quietly doubling your bill. You have to call your utility provider and specifically request the senior baseline application and the time-of-use exemption form. Just by filling out this single piece of paper, you can force the utility company to lock you into a lower, flat rate, completely shielding you from their afternoon price gouging and legally preventing them from ever shutting off your power during a dispute. Now, we need to talk about your car. If you have been driving for 40 years without a major accident, your auto insurance should be incredibly cheap. But if you look at your recent renewals, you have probably seen your premium skyrocketing. Insurance companies will blame inflation, they will blame the cost of parts, but what they are really doing is using age-based algorithms to quietly penalize you. More insidiously, they are pushing everyone toward telematics. They send you an app to download on your phone or a tracking device to plug into your dashboard, promising it will save you money. In reality, these devices track how hard you brake, how fast you accelerate, and what time of day you drive. If you are an older driver who tends to be cautious, perhaps braking a little earlier than a computer thinks is optimal, their algorithm flags you as a deteriorating driver and hikes your rates. If you refuse to use the tracker, they hike your rates anyway, labeling you as uncooperative. This brings us to the fifth protection, the telematics privacy and rate exemption. Many state insurance commissioners have quietly ruled that insurance companies cannot forcefully penalize drivers over a certain age for refusing to participate in digital tracking programs. The law recognizes that older drivers have decades of proven driving history and should not be subjected to invasive digital monitoring just to keep their standard rates. Furthermore, if you were born before 1966, you are often eligible for mature driver exemptions that legally require the insurance company to slash your premium by up to 15%, completely overriding their internal price hikes. But to get this, you cannot use their website or their automated phone system. You have to speak to a licensed agent, ideally a supervisor, and tell them you are invoking your right to refuse telematics without penalty due to your age bracket, and that you require the mature driver statutory discount applied to your policy immediately. Do not let them talk you into downloading their app. Demand the protection you are legally owed. Before we move on to the final two protections, I want to pause for a moment. We still have two major legal exemptions to cover, and I need you to pay very close attention to the seventh one. It involves a massive loophole regarding your retirement accounts, your Social Security, and a hidden tax trap that the IRS is absolutely terrified you will find out about. What we are about to discuss could be the difference between keeping your life savings in your family or handing a massive chunk of it back to the government. So do not go anywhere, because the stakes only get higher from here. Let us talk about what happens to everything you have built. As we get older, one of the greatest fears we carry is the thought of the state swooping in and seizing our assets, particularly the family home, to pay for medical debt or nursing home care. This process, known as Medicaid estate recovery, is one of the most ruthless legal mechanisms in existence. The government will allow you to receive care, wait patiently for you to pass away, and then immediately file a claim against your house, forcing your children to sell it just to pay back the state. It feels entirely inescapable, and the private nursing home industry works hand in hand with state agencies to facilitate this massive transfer of generational wealth away from working-class families and into government coffers. But here is the sixth protection, the legacy asset protection exemptions. What the state aggressively hides from the public is that the estate recovery laws contain highly specific loopholes, grandfather clauses, and hardship exemptions specifically designed to protect the homes of people in your exact age bracket. If you were born before 1966, there are legal frameworks such as specific irrevocable trusts, caregiver exemptions, and spousal impoverishment protections that can build an impenetrable fortress around your home. For example, if an adult child has lived in the home with you for a specific number of years, providing care that delayed your need for a nursing facility, federal law absolutely prohibits the state from seizing that home. But the state will never tell your family this. They will simply send a demand letter, hoping your grieving children are too overwhelmed to fight back, and take the house by default. You must proactively establish these protections now. Do not wait for a medical emergency. You need to consult with an elder law attorney, not a general practice lawyer, but an elder law specialist, and ask them specifically to structure your assets using the anti-recovery exemptions available for your age group. Setting up this specific legal boundary takes the target off your back and ensures the home you worked 50 years to pay off goes to your family, not the government. Finally, we have arrived at the seventh, most closely guarded and arguably most financially devastating trap of all. This is the absolute best point I can share with you today, and it revolves around your retirement accounts and your Social Security. You worked your entire life, you paid your taxes, and you responsibly put money away into an IRA or a 401k, believing that money would be yours to use as you saw fit in your golden years. But the government has a trap door built into the system called required minimum distributions, or RMDs. Once you hit a certain age, the IRS legally forces you to start pulling money out of those retirement accounts every single year, whether you need the money or not. Why do they do this? Because they want to tax it. But the trap goes much deeper than just paying income tax on your withdrawals. When the IRS forces you to take that money out, it artificially inflates your annual income on paper. And here is the brutal reality. If your income crosses a specific painfully low threshold, suddenly up to 85% of your Social Security benefits become subject to federal taxation. They force you to take your own money out of savings, use that forced withdrawal to push you into a higher tax bracket, and then use that new tax bracket to take a massive bite out of your Social Security check. It is a double taxation nightmare designed to siphon your wealth back to Washington. But here is the protection they are desperate to keep quiet: the silent pension and RMD grandfather clauses. The laws surrounding required minimum distributions and Social Security taxation have changed multiple times recently, most notably with the Secure Act and its subsequent updates. What the mainstream financial news glosses over is that these new laws created massive, fragmented grandfather clauses. If you were born before 1966, your age dictates exactly which set of rules you fall under, and the IRS will not automatically calculate the most favorable scenario for you. There are specific exemptions regarding how your age bracket calculates the beginning date of your forced withdrawals. By legally delaying these withdrawals to the absolute maximum age allowed by your specific grandfathered birth year, and by strategically utilizing qualified charitable distributions or Roth conversions just below the Social Security taxation threshold, you can legally shield your benefits from being taxed. The financial industry wants you to just follow the automated prompts, take the standard withdrawal, and pay the tax bill. You cannot do that. You must sit down with a fiduciary tax advisor, strictly someone who acts as a fiduciary, and tell them you want a forensic review of your RMD schedule based on the grandfather clauses for your specific birth year. Demand a withdrawal strategy explicitly designed to keep your provisional income below the threshold that triggers the 85% tax on your Social Security. This one move alone can save you tens of thousands of dollars over the course of your retirement, money that rightfully belongs in your pocket, not the Treasury's. To summarize everything we have uncovered today, the system is fundamentally designed to profit off of your silence, whether it is your local county tax assessor quietly inflating your property taxes, your bank skimming late fees and paper statement charges, hospital billing departments burying you in age-banded administrative surcharges, or utility companies punishing you with time-of-use surge pricing. The strategy is always the same. They rely on the fact that you do not know the exact laws designed to protect you. They bank on you blindly accepting auto insurance telematics rate hikes. They eagerly wait to seize your assets through estate recovery, and they use forced retirement withdrawals to quietly tax your Social Security. But now you know the truth. You have the exact language and the specific concepts required to fight back. You are not asking for a favor. You are demanding the legal protections you are absolutely entitled to. It is time to pick up the phone, audit your bills, and take your money back. I want to hear from you right now. Tell me in the comments down below which of these 7 hidden bills and corporate tricks shocked you the most. Or share your own personal story of a time you had to fight back against a company trying to overcharge you. Your comment could be the exact piece of encouragement someone else needs to stand up for themselves today. Leave a comment below, share your experience, and let's keep holding these corporations accountable together.